Algorithmic Due Diligence in Critical Resource Value Chains by Kevin Crow. The energy transition runs on lithium, cobalt, nickel, graphite, rare earths, and copper, and its supply chains are increasingly governed by machines that produce something the article calls ESG truth. Meet the compliance stack, traceability platforms tracking origin and custody, certification schemes, vendor risk scoring and automated audit triage, and, at the top, generative AI systems drafting sustainability narratives from partial and asymmetric data. Regulators present the stack as a technocratic answer to supply chain opacity. The articles claim it is a site of power, contestation, and legal risk, and legal scholarship has treated it as implementation detail rather than as part of what due diligence is. The result is a structural mismatch. The law's aims are to prevent, mitigate, and remedy adverse impacts. The firm's mechanisms are datafication, scoring, and disclosure optimization. The evidence of the gap is stark. Only about 1 in 3 companies conducted any due diligence at all. Fewer than 1 in 4 described their processes with specificity, and just 7% expressed a commitment to remedy. Proposition 1. Anti-greenwashing by design. Disclosure regimes can manufacture credibility while hollowing out responsibility. So law must discipline the methods that produce ESG claims, their provenance, their assumptions, their contestability, not just the outputs. Otherwise, the stack rationally produces algorithmic greenwashing, auditable claims without auditable methods. Proposition 2. The tools themselves can generate adverse impacts. The more compliance depends on continuous monitoring of sites and workers, the more surveillance substitutes for labor rights, appearing necessary simply because it is convenient for audit-ready evidence. Human rights law supplies the grammar. Interference must be reasonable and proportionate, and the EU's AI Act offers a doctrinal hinge, carrying rights-based constraints on worker-facing AI into transnational supply chains. Proposition 3. Sustainability that ignores taxes risks legitimacy without redistribution. Extractive fiscal practices shape state capacity shapes enforcement, and enforcement determines whether labor and environmental protections are more than paper. Ignore fiscal contribution, and you get what critical scholars have long diagnosed: moralized governance that polices the poor while leaving the architecture of extraction's profitability intact. The cobalt chain tests Proposition 1 and fails it instructively. Dodd-Frank's conflict minerals regime functioned as a de facto embargo that shifted violence rather than reducing it. The ITSCA traceability scheme was later documented tagging minerals from conflict-linked mines. The infrastructure itself became a laundering mechanism. Under-risking became governance by exclusion. Opaque risk scores cutting off the artisanal miners least able to contest them. Traceable cobalt, the article insists, is not less harmful cobalt. Nickel tests the interstate frame. Producer states contest these regimes as instruments of country-level exclusion, entangling due diligence with trade and investment law. Lithium tests participation in dignity, communities and miners enrolled as data subjects in systems they cannot see, trust, or shape. The article closes with an architecture. First, an ESG evidence chain, every claim traceable to its data, assumptions, and method, a chain of custody for truth itself. Second, rights respecting technology governance, dignity and equality constraints built into the stack, contestable by those it scores. And third, fiscal coherence, sustainability assessment that counts the taxes paid where the minerals came from, algorithmic due diligence, honestly built, not thinner obligations. Algorithmic Due Diligence in Critical Resource Value Chains, Kevin Crow.